Pistor's book palatable to you? I was lucky enough to sit in the audience when Katharina Pistor presented her initial reflections on the planned book at the Berlin-Brandenburg Academy of Sciences in 2016. She was commented on by Wolfgang Streeck at the time, and both in Katharina Pistor's lecture and in the discussion with Streeck, I, as a non-economist and non-lawyer, had the uneasy impression of having understood only half of it, given the complexity of the matter about which the two were talking about. If you read the book, The Code of Capital, however, you will, I'm quite sure, have the same impression as I do now. Here, an outstanding scholar manages to present the most complicated facts in an absolutely sovereign manner and in a completely comprehensible way. And even more, by doing so, she raises questions of utmost political importance. From the very beginning, it is simply fun to read Katharina Pistor's book and to follow her arguments, so that the reader might think, well, jurisprudence is not that difficult after all. But in fact, it is. Katharina Pistor just doesn't make it seem that way, which is why the book, for good reasons, became so famous. Therefore, please look forward with me to Katharina Pistor's lecture, which will be commented on by the aforementioned Tobias Eule. Tobias Eule, who has widely published on subject matters such as immigration law and organizational ethnography, is Distinguished Research Fellow at the Hamburg Institute for Social Research and, at the same time, Professor for Sociology of Law at the University of Bern in Switzerland. And after his comment, he will invite the audience to ask questions which Katharina Pistor will answer. Katharina Pistor, the stage is yours.
Thank you very much for these kind words of introduction. And let me say how much I really had been looking forward to spending 3 weeks in Hamburg with all of you and other fellows. We are doing everything by Zoom nowadays, and I do hope that at some point in the future we can make up for the personal interaction. So we do as best as we can, as we have all learned to do via Zoom. Let me just share my screen with you and walk you through the argument I'm trying to make today. So here's the wonderful cover slide and poster that went around on social media. I just want to say a few remarks about Max Weber himself. I was actually deeply honored when I received the invitation to give a keynote on the occasion of its 100th anniversary of his death last spring. Max Weber, of course, is this giant on whose shoulders one stands, and I had to realize with a stop that actually he died at age 56, 2 years my junior right now. So lots of work to be done still, I would say. I'm starting, I just wanted to throw out at the beginning that I don't want to reiterate sort of the caricature version of Weber's thought, which very often emphasizes his focus of modernizing theory of state and society through the greater rationality of the law, the bureaucracy, accounting rules, etc. The kind of perceived wisdom of Weber that has made its ways into World Bank think and other policy advisors. I read Weber quite differently, and I just wanted to share my thoughts on this with you today. He argued for the inevitability of greater rationalization and also of the implications this would have for the relationship between state and society, about which I will say quite a bit in a few minutes. But he also had a scathing critique of this built into his work, and I want to bring this a little bit more to the fore. So my concluding comment at the end will be that Weber's analytical power and analytical concepts that he's using in economy and society, in particular in legal sociology, the only part for which, one of two parts, I think, for which he had given approval for publication before his untimely death, And I should say he actually died of the Spanish flu. So it's, we're just drawing one arch after the other. So he died of pneumonia, which he contracted as a result of the Spanish flu. But he had approved his legal sociology for publication just before his death, in contrast to many other sections of economy and society, and certainly in contrast to economic history, the book from which most people take his emphasis on you need a rational legal system, a rational bureaucracy, a rational accounting system for capitalism to develop at all. So what is rationality in Weber's sense? He basically talks about the generalization of all relevant factors to broader principles that then guide judicial or also legislative decision-making, but especially judicial decision-making. And systematization, he suggests, comes at a much later stage. So there's a long process of generalization. At some point, systematization kicks in, which basically means that we are trying to organize these principles that we have deriven from a messy set of facts into a whole system. One of the major puzzles that is often discussed in relationship to Weber's assertion that a rational legal system is so important for capitalism is his England puzzle, or you might say the common law puzzle, because he does describe the common law as rather irrational, because it is so much tied to facts rather than broad principles. And because of the archaic gestures it's still making to sanctity of relations by, for example, requiring a consideration for making a contract binding rather than the more abstract notion of meetings of the minds. And yet Weber in legal sociology actually debunks the entire England problem by basically saying, and I quote, "Once everything is said and done about these differences in historical developments, modern capitalism prospers equally and manifests essentially identical economic traits under legal systems containing rules and institutions which considerably differ from each other. Indeed, we may say that the legal systems under which modern capitalism had been prospering differ profoundly from each other, even in their ultimate principles of formal structure." So that much on the English question, which I think we can put to rest. Maybe we can put other things to rest today as well. So I would reformulate Weber's take on the ingredients for capitalism as a dynamic interaction of different topics and themes. He basically says at some point, and I find this really very interesting, that the Middle Ages were actually crucial for capitalism to develop. The messiness of the multiplicity of forms and practices was where economic actors learned their tools and learned how to play with different forms, organizational forms, or transactional practices. And this was combined with the rationality that came from Roman legal principles, perhaps, but the Roman legal principles that had been conveyed and were rediscovered in Bologna in the Middle Ages, they were the product of a long process of Roman law. Weber himself says that the early Roman law was as irrational and complex and sometimes inconsistent as many of the Germanic figures were as well. So there's a process of a great level of pluralism and really messiness that then enters into a process of greater rationalization, which enhances the predictability of private actors to make use of these forms. If combined with greater autonomy for these actors that the legal system affords, it gives rise to a new round of pluralism within that space of private autonomy that has been created, which thrives on the fact that it can use these forms and make them enforceable because the legal system has allowed them to do so, has created the conditions for predictability to do so. So I think it's this dynamic interaction of plurality and rationality, of multiplicity of forms and evolution that is really, I find, more interesting than sort of the standard notion of rationality. Let me move on from just thinking about sort of rationality as such in the legal system to the question of power, which is the topic of my thought. Since publishing my book, The Code of Capital, I've been thinking a lot about state and state power. One of the critiques that I do get about the book quite frequently is that I haven't really developed a full theory of the state or state power, or more generally power. And so this is something I've been thinking about. And while reading about Weber, again, I came across Alan Scott's article in 2000 or so, where he asks the question where the state is in Weber, and says quite explicitly, we shouldn't ask what the state is, but where the state is. And here is a quote by him. Whereas Weber, he says, talks elsewhere about the formation of the nation state as a process of the concentration of power. And of course, that's what we have received. That's sort of the received wisdom of the means of coercion in the hands of a single institution. We are reifying the state. Here, he's talking about its diffusion throughout social networks and relationships. That's the private autonomy part. While the former has set the agenda for much of political sociology, the latter seems to prefigure Foucauldian notions of capillary power as constitutive of social relations, and thus to subvert the lines of demarcation between state and society, and perhaps also undermining Weber's own definition of power in terms of agents' will. So, what is Weber's true understanding of the state and state power? And I'm not trying to answer that question. It probably will be hard to do this for anybody, but I think Alan Scott's question to ask where is the state or where is the power is precisely the right question to ask. So where is the state power in different configurations of governance? And Weber in his legal sociology basically says there is on the one extreme, on the left-hand side of this slide, governance by consensus of elites. It's always about elites. He's quite frank about this and quite clear about this. Basically, when sort of the heads men together make decisions, they govern by consensus. At the other end of the spectrum, you can have complete state bureaucratization that fully encompasses every aspect of society. When everything is basically, he says, löst sich selbst auf, it's basically eliminated through the process of complete state bureaucratization. I frankly have been reminded of the former socialist countries, at least in the late stage, where every aspect of the state was at least asserted to be within state bureaucratic means. And he describes the modern state at his own time to be somewhere in between. Its governance, it's basically hybridic. There is sort of consensus-based governments, there's self-governance to a large extent, and there is also bureaucratization. So this then raises the question about how the two interact and relate to one another. And he starts his legal sociology really with the rather conventional distinction between public law and private law. He does assert that this is not as clear-cut in all legal systems, and not all legal systems have actually accomplished this separation, but it's quite important for understanding, I think, his arguments about the state and state power and where the state is. So in the sphere of public law, we have the state expressed and manifested itself in the bureaucracy, in principles of administrative law, but also in individuals who, when they exercise their subjective public rights, Weber argues, are in fact almost acting as agents of the state in exercising these rights, because they have been explicitly delegated these rights and they're exercising state capacity, if not state power, in this fashion. On the other end of the spectrum, we have private law. And here we have seen a process of this messiness of experimentation with different forms and practices, a very particularist notion of legal practices, to generalization, to the standardization of rules, whether in contract law and property law and the law of business organizations, and by fashioning default rules that are freely available for private parties to take. And Weber argues quite explicitly that that also is an act of empowerment, because by making certain rules default rules, they basically cannot be challenged by others, whether these are parties to the contract or parties outside the contractual relationship. The other way in which private law has empowered private parties is through private autonomy, granting private parties the power to organize their own relations while also being able to enforce them with the help of state courts and other enforcement agents. And then he also talks quite a bit about abstraction. And abstraction is really, opens up the space for lawyers, he says. And, when I was rereading this, I was stunned actually how much I had taken from Weber without always giving him credit for what he has written. But the abstraction is basically the space where what I call the masters of the code have the ability to fashion new types of assets or to bring different economic fact patterns into the remit of the legal norm. This is how Weber has put it. Individuals in the arena of private law are empowered with subjective private rights, which they can use vis-a-vis others. And they create, in Weber's own words, they create law through contracts with binding effects on other parties, but also again on third parties, because they're, by using certain standardized forms of the law, they can also wall themselves in against challenges by others. In the evolution of law from local legal regimes to legal empires, Weber, not quite explicitly, but I would argue implicitly, leaves us with two trajectories. The one trajectory is basically the territorial expansion of state administration. This is what happened in Roman law. So he describes the increasing bureaucratization and generalization of Roman law principles as directly being influenced by the expansion of the Roman Empire, the need to govern vast amounts of territory from a central hub, the city of Rome. We can see something very similar in the colonial empires of more recent times, when legal systems were transposed to those empires. And I would also note both administrative law, but also private law was transposed. And this private law then is the second trajectory of expansion, which is the expansion of private empowerment. Weber talks about Ermächtigungsnormen, so the empowerment norms that he sees already in private contract within individual legal systems. But as I will argue below, this also has been expanded to transnational relations, to the global sphere, and it's actually the very foundation of our global economic system. So when it comes to the expansion of private empowerment, he makes a couple of moves that we know from other writers at the same time, but I just want to highlight them here again. He talks about the transition from, or transformation from, socially embedded social or status contracts to purpose contracts, Zweckverträge, which have the only purpose of designing a particular transaction between the two parties and no other social relevance, whereas status contracts affect the entire set of relations of people and family relations, inheritance, etc., being the primary examples thereof. Then he talks about the extent to which private empowerment is reflexive of the law and uses the question whether liability is owed as basically the test case to see whether reflexivity has taken place. So if somebody can claim liability of another for having done certain things, then actually we see the legal empowerment of private law in action, because liability can then be legally enforced. And then, as I mentioned before, abstraction is the very source of malleability more in the arena of transactional law. And he talks about the Kautiljarjuristen and others who use the law to fit these different facts within its remit. So when we think about the longer term transformation, social transformations that happened as law transformed, as the economy transforms, and I should also say Weber makes explicit that there's not necessarily a direct relationship between law and the economy all the time. It's always mediated by power relations, either by elites or by the state. But there's rarely a direct effect how the economy affects the law, and not even the law and the economy. So the major trajectories of transformation that he observes in legal sociology that I think reach his own time in the early 20th century is the transformation from status to purpose contract, and that is accompanied also by the greater use of money. So purpose contracts and money are critical for the emergence also of capitalist systems. It's the disembedding of economic transactions from social relations. If we used Polanyi, who wrote, of course, later than Weber, we could also say it's the subordination of the society to the market principle, facilitated, but as Weber insists, and I think he's right on this, by the legal system. The second major transformative trajectory is the dominance of economic transactions expressed in money, not relations. And that is an empowerment of the asset-owning class. So he says this is all neutral. Everybody in principle could do that. But in fact, of course, only those who have assets can win the competition in the marketplace when it's all about the price mechanism and market competition. So the asset-owning class is the one that's truly empowered by the system. And the end result, and this is again important, I think, for reading Weber's own assessment of what has happened, is the increase of overall coercion. And it's exercised not necessarily by the state, but by the state-empowered capitalist undertakings, big business organizations, and the like. In some sense, we are already hearing, I think, the background music of people like Morris Cohen and other legal realists in the US. In his words here, he says, irrespective of how many rights to freedom or how much empowerment the legal order bestows on others, and irrespective of how many prescriptions and proscriptions it lifts, this is what we call deregulation today, of course. In its effect, this order may increase not only coercion in general, but the authoritarian character of this coercion. So let me make the jump into our 20th century, and I basically following Weber and the kind of transformative dimensions or trajectories that I identified in his own writing. I just want to briefly say something about the three major trajectories that I do see in our transformation of the world in the last quarter of the 20th century and well into the 21st century where we are today. And those three trajectories are globalization, financialization, and what I will call accommodation. You will be familiar with the first two, but I will say a few words about this, and then I will say maybe a little bit more about accommodation as well. So globalization is often described as the retreat of the state, the freeing up of a space for markets that can finally do what they want to do without the interference of the state. And that's, of course, the very neoliberal capture of this mode of interpreting the world around us. I think there's a little bit of that in the sense that there has been quite a bit of deregulation, certainly in financial matters prior to 2008. We have done some re-regulation afterwards, although it always goes back and forth. But my argument would be that globalization is not so much about the retreat of the state, but a transformation of state power. It's basically from state coercion to private empowerment backed by state coercion. It's basically the ability of private actors to harness state power in a relatively decentralized fashion. But it's really powerful because, of course, state power has been consolidated and concentrated, as Weber had told us. So the private empowerment has increased substantially in the last quarter of the 20th century, in part by not only the opening borders for free trade. That project, of course, started right after World War II again, but also free capital flows. And capital flows means privately created financial assets that are coded in private law, as I explain in my book, and that the different states have admitted to their own shore without any conditions as to how it will be employed. That's what free capital flow really means. It's a rather complicated legal setup to have free capital flows, but that is what happened in the late, starting in the late 70s and throughout the 80s and 90s, involving ever more emerging markets as well, as you know. Another important aspect in which private empowerment has accompanied globalization is the expansion of choice of law options, the expansion of the possibility of private parties to pick and choose the legal regimes under which they want to conduct certain activities or transactions, where you want to incorporate the choice of law issues. International private law is how we term this body of law in continental Europe. It's conflict of law, choice of law in the Anglo-Saxon world. And of course, we also have seen the privatization of dispute settlement without foregoing by that state coercion. So that's the basically international arbitration that has increased and has gone well beyond just commercial transactions, trade, but also has involved the issuance of bonds, both by private and public parties. So the expansion of all these modes of private ordering, I think, is a big theme of globalization, is very often underplayed because people focus so much on the state as being just this unitary single actor that exercises power from the top, when in fact the state empowers others by granting access to its coercive means, and private law and private arbitration does that by basically saying you can pick and choose, and yet you can still, in the end, when push comes to shove, rely on the coercive powers of the state. And then I think in the last station, I say a little bit more about this when I come to accommodation. We also see the increasing subordination of public interest to private interest. It's the big debates that we've been having over the last couple of decades about efficiency versus justice, or social welfare, where efficiency typically trumps in the true sense of the word. We have seen, of course, the invention of something like investor-state dispute settlements, which have been built into bilateral and multilateral investment and trade treaties since the early 1990s. The first one, I believe, was NAFTA in 1994 that incorporated this, where two sovereign states empower a private party to take the other state in front of a private arbitration tribunal should that state have infringed the investment of the investor. So the investor is basically empowered reflexively, its liability, to hold a sovereign state liable and do so outside the territory of that state. So this is, I think, an interesting development just structurally to think about how far states are willing to go and have gone in creating private norms of empowerment. I think the ongoing debate about patents to the COVID-19 vaccines, that is, and the question of whether private parties should hold them, and we have to rely on their production capacity rather than to expand it by also expanding the use and access to the patent, is part of that debate as well. And I'm happy to talk about this more in the Q&A. Financialization is a word that is widely used. I really like Greta Krippner's definition. Greta Krippner is a sociologist. She teaches in Michigan and wrote a very influential book, which was the outcome of her dissertation about the financialization in the United States. She describes financialization as a pattern of accumulation in which profit-making occurs increasingly through financial channels rather than through trade and commodity production. And I would just say that operations such as high-frequency trading, structured finance, all the way to the derivatives of derivatives are, I think, extreme examples of what she's describing. One could even, going back to Weber and his notion of the transformation from status contracts to purpose contract, say some of these contracts that are only about trying to extract yet another marginal financial gain from a particular transaction have become rather purposeless, purpose contracts, zwecklose, Zweckverträge. It's no longer about any real purpose. The only purpose is of the marginal financial gain, and quite irrespective of the externalities, including negative externalities, of course, this might have on others. In the context of the United States, Greta Krippner also describes financialization as basically the transformation of social policy, where almost every major social policy issue has been transformed into a question of access to credit. Credit, of course, provided by private intermediaries, from housing finance, school vouchers, healthcare exchanges, etc. And she argues that this has effectively eroded the capacity for political governance and the capability for political governance. So rather a gloomy picture, but I think one that describes our state of affair and the ability to do politics and solve complex social politics, some complex social issues through politics. I think this describes it quite well. Let me say just a few more words about what I call accommodation, and this is, I think, perhaps the next iteration in a Weberian notion of the law becomes ever more rational, and private actors are becoming ever more powerful and granted private autonomy, which the state both has to protect, but then also accommodate. The state, I argue here, is basically tasked to minimize the fallout from a marketized society. Weber uses the term Marktvergesellschaftung himself. I already noted the parallel to Polanyi. So I think we see this in particular in finance. One could argue this also is something we observe in the negative externalities for our environment that capitalism has produced. Perry Merling, who taught for many years at Columbia, is now at Boston University. He described what the central bankers have been doing, and not only in 2008, but before that, but particularly since 2008. He described this as a quixotic dance, whereby the central banks try to anticipate the needs of financial markets. And what financial markets really need is a quest for certainty. The law, they need to organize their own private affairs and to guard their own private autonomy, to create new financial assets, but they also need money, and in particular state money in times of crisis. So trying to anticipate under what conditions financial markets need state money to support them, and that's of course what we now call either liquidity support or quantitative easing, is something that central banks have perfected, and that's an accommodation of private parties or private markets. And in doing so, this is where the paradox or the contradiction comes in. In doing so, they must deviate from established norms that were created for safe markets in order to protect the markets from their own self-destruction. So it's the relaxation and the greater elasticity of law in times of crisis, where we basically say, oh, even intermediaries who have not been regulated, or even parties who didn't have access to central banks, will have access to central banks and will find themselves privileged, if they might endanger the stability of the financial market in general. So in that sense, we are seeing the irrational use of state power, which Weber in his own days had associated mostly with democracies that might want to have material, not only formal justice for their people, and would therefore relax their commitment to a rational legal system. What we're seeing here is the relaxation of rationality for the benefit of a private sector that has grown out of proportion, and I think out of proportion to whatever Weber might have possibly imagined at that time. So maybe let me conclude and leave you here with a quote from Herbert Marcuse, who wrote an article in which he critiqued Weber's positions about rationality in particular, and called it a bourgeois utopia. And he focused a lot on earlier writings by Weber, but at the end, he basically raises the question whether Weber was not also warning us about a dystopia. And here's his quote: "Or was irony hidden in Max Weber's concept of reason," he asks, "the irony which understands and disavows? Perhaps he's saying, and this is what you call reason." Now, we don't know, and I think we cannot know. Maybe Weberians who have spent much more time with this work might have a better take on that. But I think for me, it's not so much to find out what Weber really, really meant. But I think what I find intriguing rereading Weber again is sort of his analytical framework, his ability to see different forces and how they interact with one another to create the system of capitalism, in which rationality plays a role, and there might even have been a greater trajectory towards more rationality, the generalization of norms, the greater predictability of how state actors act. And he certainly was also prescient in predicting that the legal system would become ever more complex, ever more professionalized, and ever more unintelligible for lay people in particular. One might even add to that, it's become unintelligible not only for lay people, but also for many people who have been trained in the law. When you listen to private attorneys in the big law firms in New York or London or elsewhere, they will tell you that they distrust judges because they don't understand the complex financial instruments that they have created. So Weber's lasting legacy, in my mind, it might not be sort of the rationality of a legal system and the other characters that I have caricatures that I've mentioned, but rather his understanding of the dynamic interaction between centralization, generalization, abstraction on the one hand, and decentralized uses of power, renewed particularism that is built into private autonomy, and the special interests that this legal order empowers. Thank you very much for your attention.
Thank you. Thank you so much, Katharina Pistor, for truly tour de force of rereading, a critical rereading of Weber's legal sociology. I have the honor, but also, of course, the difficult task of following up on that and discussing some of the thoughts and some of the suggestions that you make. In general, I have to say I gained a lot from listening to and reading your take on Weber's legal sociology. And I think it showcases really how, in a way, broad the shoulders of the giants are that we stand on, because we can stand on one part of the shoulder and kind of come to one conclusion, but also, as you've shown, on quite some others. Particularly, of course, related to Weber's late work, in which we see a certain sense of ambiguity, because the publications weren't finished before he died. So my comments or my questions really are to be taken, I guess, in broad agreement with you, and I would kind of like to probe a bit further or take a bit further some of the comments that you make, rather than actively confronting you, because, as I've said, I think there's a lot to be learned from your take. What I found particularly persuasive is your focus on the means of coercion and the way in which the increased ability of the state to coerce also increases the private autonomy to coerce. You've called it harnessing state power for private empowerment. I think that's a very, very important part of understanding the relationship between law and capitalism in a way that is less monolithic than as you said, caricatured or maybe idealized understanding of Weber. So this focus on the means of coercion, I think I would like to highlight as one of the very, very potentially productive ways of using kind of Weber Pistorian legal sociology, so to say, today. But then, of course, there's some of the things that you mentioned are in a way really in Weber's thought himself, and one of the interesting things that I found in reading Weber that he didn't mention is that Weber actually allows for the possibility of the market to move beyond the state. Weber says quite specifically that the economy, the Wirtschaft, doesn't need the state. It just needs a certain type of security, in the sense that there is coercion that backs up these legal claims in the case of conflict. So my first question would pick up on that. Is that simply what we're seeing? Is that kind of simply what's happening right now? Have the means of coercion shifted, and do we see a different type of protection of private autonomy, or can private autonomy protect itself through these investor state arenas? So do we have a kind of a history of a shift in ownership of the means of coercion, and this is kind of the end of the story for the state? Or what is this new role of the state? You say kind of that there is a need for the state to minimize the fallout of market failure. There is a certain role, and how far is this a different role? So kind of trying to still probe you a bit more of what exactly this state that we're talking about, if state coercion as kind of key part is not so important anymore. What is the role of the state in this new situation? Because Weber, of course, also holds that markets enable state building. So it's not only that kind of the state enables markets, it's also the other way around. So in how far is this new arrangement of private autonomy and coercion something that also changes the way states can act? Or isn't there, which would be the other interpretation. And lastly, before, I don't know if you want to respond or just take the questions immediately. Lastly, I was wondering about the relationship of private and public law, and particularly in the figure of due diligence, which, as I work in Switzerland, has occupied our public discourse quite dominantly in the last couple of months or in the last couple of years. So the question is a move of kind of trying to introduce due diligence as something that has to be a way of seeing human rights. So making corporate law a kind of an entry point for something that we would have traditionally seen as arena of public law, if not the arena of public law. Is that part of this shift, of this change of means of coercion, of this kind of loss of relevance of kind of this statist side of law, or is it something else that is not related? Does the market move beyond the state, or what is the role of the state, and what is the relation of traditional areas of public law, and kind of do they encroach upon private law now in different ways? Thank you again. You have to turn your audio on first.
Thank you. I just had to get authority to unmute myself. Okay, thanks for these great questions and your nice comments, Tobias. You know, can the market move beyond the state? Yes, to the extent that it's empowered, right? And it can be empowered. And I don't think Weber was so explicit about this, but I think it's implied. It can be empowered by more than one state. And I think that is one of the reasons for the major transformations that we're seeing, right? Once private parties are not bound to a state, but can pick and choose from different states, then sort of the balance of power between what private parties can do and what public organizations or interests can do, such as polities, is quite different. I just hear myself, falling into the same trap of, again, personifying the state. And I think the question that Alan Scott posed is really the important one: is where is the state, or where is power? And I think the important question is to ask, how do new power configurations emerge, and who has access to that power, and who might have still some control rights to limit access to that power? And I think that's where we are currently. So yes, the market can be moved beyond the state, but not without the states doing, because you need at least contracts and contract enforcement. It doesn't really work quite without it. But the more freedom I have to pick and choose a state and its legal system to do so, the freer I really am from particular state configurations, but not necessarily from states as such. The dynamic also can be that markets drive states. So I think Weber sort of says it both. I think in his logic, it's more the causality of the market practices than and the law start and the law follows. I would think it's probably the other way around, but reasonable people can disagree on that one. But moving forward, the question of new forms of power, and I think that's the relationship between private parties having access to state power and using it, and we're seeing now a backlash, and that's, I think, it's due diligence that you mentioned, it's ESG, the environmental, social, and governance issues that are being debated on a global level, the questions of greater importance of stakeholders, which even the U.S. Business Roundtable has recognized in the fall of 2019, not done anything about it, but at least recognized as an important thing. I think this is basically, these are symptoms for a struggle where we're basically coming back and saying, we've drawn the line wrongly. Weber was concerned that actually democracies would use material justice to impede the notion of rationality. And I basically try to show that I think the greater impediment has come in terms of irrationality from not trying to seek justice in recent decades, but trying to allow the markets to work in the ways that is best for them and the key stakeholders within them. I think we're seeing now sort of a retreat back to a position where we say we want to have greater justice for a broader polity. And so the question will be is how can we regain, or how can political collectives regain control over the powers that private parties have learned so well to harness in a much more decentralized fashion. So I think we're in another iteration of this loop where we almost run in circles, but although in a very different way from time to time. But let's take maybe questions also from the audience.
Thank you very much, both of you. This is a exciting opportunity. Really, it would be more exciting if Katharina had been able to come. As it is now, it becomes both transatlantic as a dialogue between Weber and modern American ideas, but also between Tobias here in Europe and Katharina in the United States, and of course transdisciplinary in both bringing together, I suppose, from both sides, disciplines here of sociology and legal studies, really. And so my hope is indeed that we can broaden the discussion here, and I invite participants both on Zoom and watching on TIDE TV or YouTube, indeed, to provide me with questions or inputs. I'll maybe ask the first, although I already see the first question is there on TIDE TV. You started by quoting Alan Scott as asking, where is the state? You ended by quoting Alan Scott as saying, where is power, right? And so there's a certain transformation in the argument from centralizing the state to making this about power. There's a second transformation, it seems to me, in your presentation, where you begin by saying that, of course, Weber's distinction between public law and private law as such is problematic, but where through the argument you distinguish private interests and public interests. And so my question just to you, in the face of the developments that you name, globalization, financialization, accommodation, can we still center the state in the same way in which we did before, as representative of power first, whether centralized or decentralized, and representative of public interests, as it still seems to be strongly in your normative project? Or would we have to decenter the state in our analyses today and then either rethink or replace concepts like public and private in such an analysis? And I'll invite people to ask questions and provide me with further comments that I'll share then. But first, Katharina.
Yeah, thank you. Yeah, so a great question. So I think, I think one cannot help but reinterpret Alan Scott's question from state to power, because once you say the question is not what is the state, but where is the state, then we're basically not looking for a particular personification or particular actor, not a single actor, but we are looking for where is something that is of the state or that we have essentially associated with the state being manifested. And what this is that has been associated with the state is the centralized means of coercion, access to institutionalized forms of power. So I think you could say the legal system is actually a particular way in which we have institutionalized powers, and we also, by doing so, have institutionalized access to that power. Now, who is the we, right? So that's the question. Is of the polity, the political self-organization, is this the same as the state? And then you basically make the abstraction from people to state power agents, or should we start with a more diffuse concept of exercise of state power, and then ask more specifically through what institutional manifestations can this power be exercised? So, should we still do the same and sort of locate the state on the one hand and the market on the other, the public versus the private interest? I've done this. I've had my own slippage in the presentation. I concede that. I think we can still certainly identify different interests, powerful different interests. But the simple divide between public and private, market and state, might be truly too simplistic.
Thank you. So Ben Bakalovic has a related question that he calls maybe a little broad, but he's curious. All around us, the questions of state power are currently being posed. Is this just a current academic trend? Is it due to globalization or something else? And maybe I'll add a half question on that. The early globalization talk on the retreat of the state and talk about law without the state seemed obsessed with the state almost, right? So it's a curious bifurcated analysis that we frequently see. On the one hand, we claim we're moving away from the state, but we're doing that by constantly talking about the state. So why is the state so centered in our analyses? Is this just a current academic trend, or is it something else?
I think academic trends actually reflect broader trends in society and the world as well. So I think it's in that sense, it's certainly something else. I think there has been this, as you suggest, there has been this debate about sort of, the state is not needed, it's an interferer, and markets can be freed from the state, they can do it without it. But you're right that very often it was like you have this enemy picture, right? Like in many political debates, we need sort of an enemy to talk about, and so the freedom of the market is contrasted to the powers of the state. And then you have, of course, the counter movements bringing the state back in. There are Skopal and others who have started this movement much earlier. And I think we're still too much wedded to these simplified concepts. So why is this happening today? I think today we're having this backlash against neoliberalism, the failure of markets, the huge externalities, negative externalities that markets have created, the reflection on how social societies are organized and what actually state power can do during COVID, right? Who has rescued economic systems to the extent that they have been at least rescued temporarily from the fallout from the COVID pandemic? It's been enormous intervention in those terms, again, enormous mobilization of collective forces, whether it's money sources or tax sources and other social resources that have been mobilized through a collective undertaking. I think this falls in the face of earlier presumption that, the markets can fix it and leave it to the markets. In fact, if and when we introduce market principles, such as competition between states over COVID vaccine, we see the failure of the entire project again. So I think it's not only a fad in academia, I think academia reflects a broader critique and maybe even mistrust of the recipes that were so prevalent for several decades.
Thank you. I would be very glad to bring others into the debate and also bring Tobias back in if he wants to. And until either of those happens, I'll just push a little further in response to what you said now, which is we relied on market principles for distribution of COVID vaccines. Of course, we relied on market principles on the provision of face masks. But of course, as you said earlier, there was no we, right? There was basically anarchy in which powerful actors stole masks from others on airports, really in an image of that seems like the total absence of the state as we imagine it in a Hobbesian way, except most of these were state actors. They were just actors of different states. So coming back to what you already questioned yourself before, you say we introduce market principles or we provide other ways of distribution. But one aspect of globalization is, of course, what you said. If we can explain as the privatization of the states now being themselves subject to regulatory competition, to limited regulatory powers, and of course, emerging asset classes, again, if you want, of rich states, which now are closing up on full vaccination, and poor states or poorly run states like Brazil and India with disastrous situation. So is this hope of state power which centralizes and therefore represents the public, is that not an illusion anyway? And therefore is our space of action not limited in that regard?
I mean, yes and no. I think there are some powerful central actors. Perry Merling, to quote him again, he said years ago after the financial crisis of 2008, forget the G20, watch the C6. The C6 being central banks. And of course, it's not so surprising because given the extent to which financial markets have been integrated, I think, again, through active participants of legislatures and states and regulatory moves, not only deregulation, but positive legislative and regulatory moves. But to the extent that markets had been created, the capacity to prevent a complete meltdown of these very markets rested ultimately with state agencies. And these were central banks and in part also legislators who went in and did major bailouts. I think, again, with COVID, we've seen the all the vaccination programs, even sort of the move towards vaccination, massive amounts of subsidies given to pharmaceutical companies. And then, yes, and sometimes the use of centralized powers to the detriment of people outside that power. If I think about the United States, basically using the Defense Act to say you can't export anything before you have fulfilled our contracts. And then I think the Europeans realizing only later on that most of the vaccines had already been sold, and the contributing things as well. So there are these elements still, I think, of centralized power that are being used. So you're right. I think that the state itself has become increasingly the object of marketization, of competition between them, but by choices of legal processes that are still within the grasp of ordinary legislative processes, legislatures and other actors that can be mobilized. Whether this can be done again to satisfactory end, or whether one should rethink about how we organize our polities and our political interest and our collective interest in achieving certain things at a much more fundamental level, I think that is also up for grasp. I think we're seeing increasingly debates about the limits of our current representative democracies and etc. So the way we configure access, collective access to state power, probably has to be rethought just as much as we are rethinking the way in which private individual economic actors have access to that resource, which I think is still relatively centralized, even though access might not be.
I'd like to probe you a bit further, and I think it goes back to this question of where's the state and what kind of state are we actually talking about. From this discussion, it seems like what the markets need is legal certainty, which has to do with a kind of legal code that is somewhat comprehensive and somewhat comprehensible, and a judicial system that backs it up, and some kind of state order that kind of puts weight behind this judicial systems. But this could be any kind of state that doesn't need to be a democratic state at all. It doesn't need to be a state that cares for human rights, or it doesn't need to be a state that has any kind of social welfare system. It doesn't need to be a state that fulfills diplomatic obligations to other states, even if there's a competition about states. So what does that mean for also kind of our perspective of kind of developed states in which kind of interact across all of these dimensions? Because in a way you could say the ideal type is Hong Kong, which is kind of getting rid of all of these proto-civil society aspects, but has this financial power and the coercive power so is that kind of the ideal state situation in this new globalized relationship between state and market, or is there any space or any relevance even for other aspects of the state?
Well, it depends on which perspective you take, right? So let's just say we have multiple interests and multiple normative goals as well. And I think for the perspective of members of the financial industry, including the lawyers that serve that industry, Hong Kong or Singapore are the ideal types, right? This is basically where you get the certainty of the law without the messiness of the politics. And actually Weber saw that too, right? So you have basically eliminated the problem of having rationality messed up with principles of justice and democratic demands, and you can just serve exactly that predictability, right? There's a downside, of course, if markets overdo it and you have financial crisis. That's something that has to be put into the equation as well. But in terms of a of a legal system that provides the input that is needed for a financial sector to expand and to log in private gains, that's precisely, I think, what most of them would want. And there are few who say anything against what happened in Hong Kong and on the democratic side. So I think, and so this is the conflict, right? Is how resources that have been created by in a very complex process, but resources that are not only of the financial sector for itself, but it's a general resource, a legal system becomes captivated by some major players. And the question is, under what conditions are there possibilities to either take away or harness this power for different purposes as well? So it's certainly not the ideal type for anybody who's interested in a more pluralistic form of governance and different normative objectives, whether this is self-governance, justice, poverty alleviation, etc. That is not the system that is ideal. So I think what is interesting about these debates is that we're coming back to really normative debates. We have, under the age of neoliberalism, if you want to call it that, we have very much focused on sort of this efficiency paradigm as the overarching one, where we don't have to ask these questions because somehow they're the same, right? Kaplow and Chauvel wrote this book about social welfare basically being efficiency. We only sort of follow these goals, then ultimately we will achieve what is best for everybody. And I think it's time that we have these kind of debates again, but it's also, I think, high time that we harness the collective powers that we still command to different ends.
So when you put Hong Kong on the one side as a state with a greatly functioning legal security for matters of finance and weak values on democracy, what about, on the other hand, very weak states? What about some states in the global south, where your hope in the state's ability to regulate may just not be fulfillable? So a lot of the literature that you name that says essentially we can do everything through efficiency is basically US literature, right? And that's in part because of a certain US tradition of praising markets, but it's in part because of a strength of the United States that can afford all of that, and then some welfare because of its strong power and its strong extractive powers in the rest of the world. But for lots of states elsewhere in the world, that's just not a possibility. So how does what you say translate to areas in which what we understand to be the state is something very different from this ultimately Western global North concept?
Yeah, again, I'm not entirely sure whether it's so fundamentally different, because I think many of the development policies that have been brought to the global South very much reflect these ideas. I mean, the institutions that are bringing these ideas south are, Washington-based Bretton Woods institutions, and I think they have also basically transplanted both the ideas and the mechanisms for that. I mean, you and I at different stages have been involved in the doing business indicators of the World Bank, right? And that's one of the transmission belts. It's not the only one. I don't want to diminish, however, the notion that there are many states that are effectively failed states, or the notion of, Paul Collier's the bottom billion. There is a bottom billion people who live in effectively failed states. I think these states are quite different. They're typically captures, a small elite captures the power that we associate with the state, but there's a small elite that typically has control over the centralized means of coercion and uses and abuses it in such a way that many are excluded from it completely. How to get out of that? I think that's the big debate that we're having, right? But the question that comes back to is, again, who should, as a normative matter, have access to the centralized means of coercion, and how is that access being institutionalized? One of the difficult legacies that many colonial former colonies had to deal with when they became independent is that they were handed over a state apparatus that had been built up during the colonial power period, but that hadn't been geared or institutionalized towards a meaningful self-governance apparatus. And that transition has not happened in many countries, and where it has happened has been enormously difficult. One positive example, I think, for decades had been India, which rejected many of the more capitalist notions, which changed its constitution and downplayed property rights from a fundamental rights to something else, which had very effective vaccination programs in the past. Before it, Modi had this crazy idea of bringing competition back in. So I think there are also examples in the global South where you can look at governance mechanisms that actually have had pretty remarkable and positive effects on larger parts of the population. Never alleviated poverty completely. I'm not naive about that either, but had accomplished to reach broader parts of the population in a rather effective fashion.
Thank you. I have a question now that I'm going to read from Kardilin Gunaydin. In the conclusion of your book, you stress the indeterminacy and malleability of private law as explanatory features of its dominance. How would you understand the role of the state beyond its abstract complicity, for example, between labor-capital struggles? And how does such a differentiation influence your alternative gradual change approach, influenced by Menke's analysis of transformation of rights? Thank you.
Yeah, it's a difficult but also a very good question. So I think again it comes down to down to me, again, to the question of whether there is a single act of the state that enters into a coalition and alliance with a particular other elite, which could be the powerful economic interest, could be other interests as well, and then how can you extract it from that? So if there is a powerful affiliation, association between that state actor that we personify as a state actor and powerful economic elites, then the question is how can we wrestle this away? My reading of the world is that it's a little bit more complicated, that sort of the harnessing of state power happens in a much more decentralized fashion, which also gives then strategic actor the opportunity to try to find the soft spots where it can close the opportunities to access state for certain types of purposes in this fashion. So I think the question for me is how can we reconfigure control over and access to collective means and resources such as the law or the coercive powers that we associate with the state, but how can we reconfigure this in such a way that others have greater power to it? Some of the measures that are being taken might be small steps, but they're important steps, whether you, for example, empower labor unions and collective bargaining, whether or not you provide minimum wages. These are, I think, some measures that the Biden administration has now taken, which shift marginally, but in a direction that's quite important. Christoph Menke's ideas about, moving beyond the subjective rights, I actually think he also has a lot from Weber in his own thought, but moving beyond the subjective rights and thinking of them as more temporary rights to achieve certain purposes, and that should not entrench forever, something that actually was pre-legal, pre-constitutional in many legal systems. I sympathize with some of the arguments that he's making. I just haven't developed a meaningful way yet to operationalize them. I'm not sure how you would operationalize them, how you would ensure the temporariness and the switch to other groups and how to make these kind of decisions. And maybe that's, a task that we have to all think about much, much harder. But I think that's where basically, I use his argument in a way as just to say, one could think in this direction. I'm not sure how to do this, so I'm taking a middle ground, a strategic move that gets you out of trouble in the end of the book, but I think it's not entirely satisfactory, so I get that point too.
So Wolfgang Knöbel has a question that also concerns doability and enforceability, but coming back to the Global South, he points out the debate on weak versus strong states or failed states is an old one, and the results were not very impressive because of the simple fact that the so-called weakness in the Global South, he says, will not go away. And how then, he asks, should we discuss normative questions when there is no addressee in the Global South, at least not an institution which does look like the state in a Western sense?
Well, that's I think in some ways that's exactly the problem, right? That we talk to people only once they look like us. And if they don't and can't, then we can't talk to them. And I think that's basically the way in which we have institutionalized relations at the global level, right? Even in countries that have become complete failed states through civil war, the UN can come in only once we have another new power that is recognized as something like a representative of the state. There's no other way to start negotiations, to bring loans in, to deal with issues. But I think that's part of the problem. There is a geopolitical structure built into our international relations that also reinforces the fragility of many political orders that can't be configured into this. Now, what I don't want to be so naive and idealistic to think that they could be configured into some stable social orders under different circumstances. But we know some hotspots in history that have been hotspots forever because they were always contested. there's no stability of any kind. So Weber had some points here. We need some basic stability and predictability to have thriving polities and economies. And so Afghanistan is one of the hotspots. The Middle East has always been a hotspot with different political configurations. So I think we have to learn from that as well. But beyond that, I think we also have to think very hard about how to, who actors on the other side can be, whom to engage in conversations about how to structure institutions such that they operate in those communities, that they can, serve themselves in a way, rather than imposing both structures and conditions that might serve outside actors primarily rather than inside actors. I think there are, lots of examples one could point to. One could point to the failed UN interventions in failed states, whether in East Timor or also to some extent in the Kosovo, how locally grown new institutional structures were destroyed because they didn't fit the typical model that we have seen. And so one of the, I think, fundamental failures of international interventions in many countries in the global south has been the attempt to reconfigure whatever they've seen in the image of the global north. And that's part of the problem, not a solution.
One of the key challenges then seems to be the question of involved stakeholders. Stakeholders in the question of who is involved in making up state power or deciding how state power is used. Stakeholders in the question of who is part of international relations or transnational relations, and stakeholders in the question of who can actually use these coercive means or as a harnessing power in relation to law. And particularly this last point I find a bit puzzling, and maybe we can unpack that a bit more. Why, if kind of the coercive power of the state through law is so strong, why is it only particular actors that benefit from it? Or what do we have to change to level the playing field there? Is it a question of kind of the old access to justice discussion, that the cost or the knowledge barrier is so high, or is there more involved? Is it more related to kind of this internationalization of the relationship between coercion and markets? So why, if we think about a working legal system, why is it so difficult to only have some people benefit from it?
Well, I think it's a mixture of some of the factors that you have identified already. It's certainly a question of knowledge, legibility, and access, and that includes, lawyerly advice. We recently heard a presentation from one member of our faculty at Columbia who told us that the vast majority, over 75% of all civil disputes in American state courts, this is the vast amount of all civil disputes overall, do not have any legal representatives anymore. The so-called adversarial process that lives from having a lawyer on either side and having debates in front of the judge, and the judge being entirely neutral and only supervising, in 75% of all civil law cases, this is no longer happening. It's beyond the means, and the lawyers are doing much more lucrative things elsewhere. So, I mean, that's just, you just see how this is like an extreme evolution over time that has taken place. But I think we should also, this is not an old debate about whether poor people have access to justice. It's sort of a present debate in the United States. How can you have a civil dispute over evictions, over claims to, contract disputes, property rights disputes, and you name it, family, of course, divorce as well, without any, in the law, without the law. So I think at some level that, of course, raises the question whether the legal system is trying to do too much, where there are many issues where different forms of dispute settlement and organization of both state resources and collective resources would be needed. An overextension of a resource that we thought could fix everything but cannot might be part of that problem as well. So I think that's part of it. In Weberian terms, I think he probably would argue it's sort of the combination of sort of the generalization of the legal principles, the granting of private autonomy to empower private actors, also empowers systematically those who have the greatest resources. So there's sort of this an irony built into this. I wouldn't really want to advocate like narrow, rigid rules, which of course could also be arbitraged around quite a bit. But I think the greater flexibility that the private law in particular has used does empower people who have the best resources to use it. And I think what I'm suggesting at the end of my book as well in the current context is that, for example, courts might, to the extent they're involved, when they enforce and execute judgments, maybe they should have a second thought about whether this is compatible with other principles and norms, whether arbitration can be used for borderline cases that look a little bit more like inflicting burdens on the public interest or collective interest rather than advancing private interest overall. So I think we have to, it's not only a little bit more of this or that, but I think it's we have to think beyond the current configurations of law and state that we have to think about how to address areas of conflicts and tension and contestation in society with different means and institutional devices. And in doing so, also be really mindful of the fact that the majority of people, even in countries that are as legalistic as the United States, are completely excluded from the legal system as consumers, while they're, of course, objects of the systems. They're creditors, they're renters, they're homeowners, they can be evicted, et cetera, but they don't have access to justice, even for the most simple forms of civil disputes. And let's not even talk about the criminal law system here. You read about this, unfortunately, every day in the press.
So let me move you back to the questions of the theory of the state. Wolfgang Knöbel asks, he says you rely on a number of authors. You rely on Weber, Scott, Krippner. Do you see any other current political sociologists who might help you frame the question of the state in a different way? Let me just name two that I can think of that would maybe be more critical of the state. One is the other Scott, James Scott, with his Seeing Like a State, and the suggestion that that's just how states behave in high modernism. And so to avoid the problems, we'd have to avoid states. And the second model that comes to my mind when we spoke about India is Shalini Randeria's idea of the cunning state, which she says is the state that deliberately makes itself less powerless than it could be, deliberately subjects itself to proclaimed global market forces in order to not have to do the relevant and necessary steps to protect the poorer parts of its own populations. So those are just two examples I can think of. Others can think of others, but how about more radical critics, if you want, of state and the configuration of the state altogether?
No, I think I'm pushing myself to that as well. I think I'm probably more of in the middle ground theorist, but I think the questions that come up through the research that I'm doing sort of point in that direction. I guess with James Scott and Seeing Like the State, I find it a bit too one-sided and too extreme, the way that he portrays it, and I also don't think that. I mean, there might be something inherent in the, concentration of power, let's call it consolidation, the pooling of resources, including the pooling of power to create stability, I think is inevitable, right? So, there's a reason that we've tried to overcome feuds and self-help. And so one could think of other forms of self-help that might be regulated, but that would have to be regulated and constrained somehow if you want to have some level of stability. And that this consolidation and pooling of resources of power can lead to the forms of extreme bureaucratization and silo thinking and behaving and structuring everything in this way. That's, I think, an important insight, but I think it's also, does not necessarily reflect of the plurality of interests that have shaped modern states. So I think I'd rather sort of think of, so I think of states of much more, decentralized in the interest of some powerful players, and the rest might be either, cunningness, or might be a charade or a display of a collective interest that is not really practiced, but is still being upheld as a facade. But I think, more to the point, and just to throw in a variable that we haven't even mentioned yet, that also has been of quite concerned my recent writing, is the question of new forms of sovereignty and digital power, right? The extent to which some private powers can organize control over others in completely new ways, using currently the legal system and to some extent protection from, but also of state power to build these power base, but that could completely alter our and are already in the process of altering our relations with one another and to the state. An integral version of that we can see in China, but I think in the West we see sort of currently a kind of a competition going on. So there are new constellations of state or of sovereignty or power that are breeding that one has to look at. And my interest is basically to understand the construction of these power centers and the extent to which they are contestable normatively, but also practically in terms of overturning them or changing them, changing the key powers. There are some more radical ideas out there. I've been reading Elaine Landemore's Open Democracy, which is not the liquid democracy so much that is sometimes debated in the German political context, but tries to move beyond that. So trying to get direct participation of the people on specific issues on a temporary basis, using lotteries and others to bring people together. Whether this is scalable and functionable are all things I think that should be, investigated and thought through very carefully. But I think we are at one of these moments where one radically questions the structures that we have and tries to find inspiration from a multiplicity of writers and ideas to rethink.
Perhaps that's the moment where I'm forced to say that in Switzerland, where direct participation of voters in lawmaking, in changing the constitutions is common, the key lesson is that people vote with economic interests and not against them. So the question of resolving these questions of interest and
yeah.
Exertion might not be just kind of solvable through this idea of opening participation, and that of course again goes back to a kind of Wittberian skepticism of these processes and of the way.
Well, so I think, Landemore at least differentiates her ideas very clearly from direct democracy, and certainly from representative democracy through referenda, with a little bit of direct participation with referenda. So I think one has to really closely look at the model, and sort of she thinks that it's actually direct participation in decision making, and basically the elimination of sort of elite-based representative democracy through direct participatory processes. And then the question is how you construct the pools of knowledge and expertise, how you make sure that they're sufficiently diversified. So the whole idea is to bring people in from different walks of life and different backgrounds for deciding direct issues that are relevant for all of them, and so that would be, I think, a more radical departure than what I think the Swiss model has to offer for representative democracy.
So we are going to close relatively soon, but I have one more question from the chat that could be a big question, but can deserve a short answer. So you move from state to power, says Wolfgang Knöbel, where power is really Macht. And this question is, why not move to Herrschaft instead, to domination instead? Also maybe in tune with newer political theory, Philip Pettit's ideas on domination, etc. We speak about power a lot in our legal discourses, in the public-private distinction very much. Might that be a more helpful term, given how imprecise power really is as a concept?
Yeah, and I can see that point. Maybe because what I'm trying to get at is what Weber calls Zwangsgewalt. So the ability to impose on others certain rules and restrictions on what they can do, to suppress their urge to do certain things, and maybe to abide by other principles. I think that the question to me is how we would configure institutionally, and how we have configured institutionally this access to this what I call coercive powers of the state, and that is, however, that serves an important function in building up power elsewhere, private power elsewhere, whether it evolves into dominance, I think that's an empirical question. I think one can hypothesize that it very often will. And I think Weber would also say that many of the already dominant elites took advantage of this new institutionalization to further advance their dominance over others. But I think in a more neutral fashion, one could imagine, I think we, in a much more relatively egalitarian pluralist society, we would still have coercion, right? I mean, at least I do not believe that complex societies or societies in general can be governed in the complete absence of coercion. But I would hope that they might be governable without some exercising dominance over others, right? I recently listened to a lecture by Christoph Menke where he asked sort of this question also fundamentally again and again, is of when do you have power over others? Under what conditions can you exercise power over others? And so in that sense, dominance is always problematic, would have to be, legitimized through process of accountability, etc. But a related, though still separate question, at least in my mind, is the question of sort of the access to the pooled coercive powers and how we structure that, and structured in part also to avoid dominance. I think, when you think about antitrust or other mechanisms that are used to mitigate private dominance, for example, so I think we have to analytically differentiate between them. But I do recognize that the most difficult to grasp, has always been the most difficult grasp concept, and not only for me, I think, is the concept of power, Macht. So as you can see, I'm not entirely clear about this yet, but my instinct says we have to, we probably need all three concepts: the Zwangsgewalt in terms of coercion, Macht is a more diffuse concept, and Macht that can crystallize in some forms of dominance of some over others.
Wonderful, thank you. I have to say two things that have always impressed me about Katharina Pistor, amongst many others, is one, her optimism to actually work out solutions and not just critiques, and second, her ever-growing curiosity in moving theories further, including critiquing her own. So I think we've seen a lot of that today. We've seen a lot of learning today. We've seen a deep discussion today. And I think we all leave this meeting with more ideas, but also more knowledge and insight than we had before. Thank you very much for that, Katharina. I will close this now, not without saying that tomorrow we have the second presentation in this now shortened Weber series by Professor Jedediah Purdy, who happens to be a colleague of Katharina Pistor in Columbia Law School, who will talk about law and political economy. So that is so related that it will certainly be worthwhile coming into that again. There are further events around Katharina Pistor that you can find on the websites either of the Hamburger Institut für Sozialforschung or indeed the Max Planck Institute for what's her name? Comparative and International Private Law. For now, thank you everyone for attending. Thank you, Wolfgang Knöbel, Tobias Eule, and most of all, of course, thank you, Katharina, for sharing your wisdom and insights with us. Have a good night, everyone.
Thank you, Ralf, Tobias. Thank you, Herr Knöbel. See you soon. Hopefully in person sometimes. Cheers.
Bye-bye.